When you start trying to wrap your head around all the rules for workplace fairness, discrimination, harassment, it can feel a bit overwhelming, right?
Oh, absolutely. There's just a sea of information out there.
Exactly. So for this deep dive, we wanted to really focus things. Our mission is to pull out the absolute must-knows for you, the listener, about preventing discrimination and harassment, specifically looking at federal law.
And we're going straight to the source, the Electronic Code of Federal Regulations, the eCFR.
Right, the eCFR. Could you quickly remind us what that is?
Sure. Think of it as the government's, well, official online rulebook. It's constantly updated. And for what we're talking about today, labor law, the big one, is Title 29.
Title 29. Got it.
And within Title 29, specifically Chapter 14, that's where the Equal Employment Opportunity Commission, the EEOC, lays out its regulations. It's the core stuff interpreting those anti-discrimination laws.
Okay, so Title 29, Chapter 14, that's our main playground today. But looking through the sources, it seems these issues pop up elsewhere in the eCFR too. It's not just Title 29.
No, not at all. And that's actually quite revealing. It shows how broadly the federal government views this. You find related rules in, say, Title 45, which deals with public welfare.
Public welfare, how does that connect?
Well, it has rules protecting unaccompanied children from sexual abuse and harassment in certain facilities. Then there's Title 28 for correctional facilities, Title 41, which talks about federal contractors' duties regarding sex discrimination and harassment.
Wow, okay. So contractors too.
Yep. And even the Federal Reserve, that's Title 12, has its own internal anti-discrimination policies. It really demonstrates the scope.
It really does. We saw mentions for the Relocation Commission, EPA programs covering age and disability, even parts of Title 29 covering things like WIOA, apprenticeships, OSHA, USERA.
And the Department of Justice's own rules in Title 28. It's quite widespread.
So while Title 29 is key, understanding this broader context is important.
Definitely. So for our deep dive, we'll hit the main regulations: sex, religion, national origin, age, disability, and genetic info. Then we'll look at what employers need to do proactively, prevention. And finally, zoom in on specific guidance for handling harassment itself.
Sounds like a plan. Let's start with discrimination based on sex. It's Part 1604 in Title 29, right? And it doesn't just apply to the direct employer.
That's a crucial point. It covers employers, yes, but also labor organizations, employment agencies, basically anyone whose actions might impact job opportunities based on sex.
Okay. And a big chunk of that is Section 1604.11, dealing with sexual harassment. How does the eCFR define that?
It's quite thorough. It includes unwelcome sexual advances, asking for sexual favors, and any other verbal or physical conduct of a sexual nature. The key is that it's unwelcome.
Unwelcome, right.
It also covers situations where, putting up with it is made a condition of keeping your job, or if rejecting it leads to negative job decisions.
Yeah.
And crucially, conduct that creates an intimidating, hostile, or offensive work environment.
So it's the quid pro quo stuff, but also that hostile environment piece. What about coworker harassment? Is the employer on the hook then?
They can be. The rule says an employer is responsible for harassment between coworkers if the employer or their supervisors knew, or frankly should have known, about it and didn't take immediate, appropriate corrective action.
Should have known. Okay.
And interestingly, this responsibility might even extend to actions by non-employees, depending on the employer's level of control over them.
That makes sense. You have to maintain a safe environment. And the regulations seem to really push prevention as the best approach.
Absolutely. Prevention is stressed as the best tool. Employers should take all necessary steps. That means informing employees of their Title VII rights, how to raise concerns, and developing methods to sensitize everyone.
And beyond harassment, Part 1604 also addresses other forms of sex discrimination, like job classifications.
Yes, things like labeling jobs male or female, or having separate seniority tracks based on sex that's generally illegal, unless being a particular sex is a bona fide occupational qualification, a BFOQ.
And that BFOQ exception is pretty narrow, I gather.
Very narrow. You can't use stereotypes like women aren't strong enough for this job, or what coworkers or customers might prefer. That doesn't cut it.
Right, no stereotypes. And it also mentioned that Title VII generally overrides older state laws that might have limited women's work.
Correct. Those old state protective laws often conflict with Title VII and are superseded. The guidelines also cover non-discriminatory fringe benefits, and ensuring pregnancy-related disabilities are treated like any other temporary disability.
Okay, let's shift to religion, Part 1605. The big theme here seems to be accommodation.
Exactly. The core idea is the employer's duty to reasonably accommodate an employee's or applicant's religious practices. The only way out is if it causes undue hardship for the business.
And religious is defined pretty broadly.
Very broadly. It's not just traditional organized religions. It includes moral or ethical beliefs held with the strength of traditional religious views, as long as they're sincerely held.
Okay, so what does reasonable accommodation look like in practice?
Well, the eCFR gives examples like voluntary shift swaps, flexible scheduling, maybe a lateral transfer, or changing job assignments. They specifically encourage employers to help facilitate those voluntary swaps.
Makes sense. Trying to find a workable solution. What about during hiring? Any pitfalls there?
Yes, employers need to be careful. Asking about availability during scheduled hours before a job offer, for instance, can be problematic if it potentially screens out people based on religious observance needs, unless there's a clear business necessity.
Good to know. Okay, next up. National origin discrimination, Part 1606. This also sounds quite broad.
It really is. The EEOC defines it broadly to include not just where you or your ancestors were born, but also discrimination based on physical, cultural, or linguistic traits associated with a national origin group.
Linguistic traits, too. Wow.
Okay? Or even discrimination because of who you associate with, or your name, or even your spouse's name.
That's comprehensive. And like the others, there's a duty to prevent harassment based on national origin.
Absolutely. An affirmative duty to maintain a workplace free from it. That includes preventing ethnic slurs or any conduct that creates a hostile environment related to national origin. And again, the employer can be liable for coworker or even non-employee harassment if they knew or should have known and didn't act appropriately.
Got it. And what about language rules, like English-only policies?
Ah, yes. The rules state that blanket English-only policies, requiring English at all times, are generally presumed to violate Title VII. They get very close scrutiny.
So not usually allowed unless there's a very specific, justifiable reason.
Exactly. And the EEOC also looks closely at selection criteria, like height weight rules or fluency requirements, if they disproportionately screen out certain national origin groups, referencing the UGESP guidelines.
Okay. Moving on to age discrimination, Part 1625, interpreting the ADEA. This protects folks aged 40 and over.
That's the baseline. The ADEA protects those 40-plus from discrimination in, well, everything: hiring, firing, pay, promotions. An interesting point, though, is that favoring an older worker over a younger one, even if both are over 40, isn't illegal under the ADEA.
Okay. What about job ads? Any language to avoid?
Definitely. Avoid terms like young, recent grad, or specifying a narrow age range like 25 to 35. That could deter older applicants.
But saying things like retirees welcome is okay.
Generally, yes. Preferring older workers is fine. And while asking for age isn't automatically illegal, it's scrutinized. It's good practice to mention ADA protections on applications.
And is there an age BFOQ, like with sex?
Yes, but again, very limited. Age has to be reasonably necessary for the specific business operation. The burden of proof is on the employer.
Okay. And what about practices that aren't explicitly about age but might affect older workers more?
That's where reasonable factors other than age, or RFOA, comes in. If a policy negatively impacts older workers, the employer has to show it's based on a reasonable factor other than age. The RFOA defense isn't available if age itself is an explicit limiting criterion.
Right. And quickly, seniority systems and benefits.
Bona fide seniority systems are usually okay, but they can't force involuntary retirement based on age. Benefit plans generally can't discriminate against the over 40 group, though there are some complex rules around cost justifications for certain age-based benefit reductions. And any waiver of ADA rights needs to meet strict knowing and voluntary standards.
Gotcha. Let's tackle disability discrimination now, Part 1630, the ADA. Key here is the broad definition of disability.
Absolutely. The ADA Amendments Act made it clear that disability should be interpreted broadly to cover more people. The law prohibits discrimination in all employment aspects for qualified individuals with disabilities.
And the concept of reasonable accommodation is central here too, isn't it?
It is. Employers must provide reasonable accommodations for known physical or mental limitations of a qualified individual, unless it causes that undue hardship.
And examples might be
Modifying the application process, changing the work environment, like providing assistive tech or flexible schedules, adjusting how job tasks are done, making things accessible.
But it doesn't mean lowering essential job standards or causing significant expense.
Correct. That's the undue hardship limit.
Yeah.
Also, any qualification standard or test that screens out people with disabilities must be job-related and consistent with business necessity. Tests have to measure ability, not disability.
And there are strict rules about asking about disabilities or requiring medical exams, especially pre-offer.
Very strict. Pre-offer inquiries about disability are largely prohibited, and any medical information obtained post-offer must be kept confidential in separate files.
It also prohibits discriminating against someone because they're associated with a person with a disability.
Yes, that's an important protection. You can't discriminate against someone because, say, they have a child with a disability. And of course, no limiting or segregating employees based on disability, and no retaliation for asserting ADA rights.
Okay, last category, genetic information. Part 1635, the Genetic Information Non-Discrimination Act. GIANA, maybe less commonly discussed.
Perhaps, but incredibly important. GINA prohibits discrimination based on genetic information your own or your family members in employment decisions.
And generally, employers can't even ask for this information, right?
That's the main rule. No requesting, requiring, or purchasing genetic information. There are a few very narrow exceptions, like if it's acquired inadvertently or voluntarily provided for a wellness program with specific authorization or needed for FMLA leave certification.
But even if they get it legally through an exception, they can't use it to discriminate.
Absolutely not. Use is prohibited.
And confidentiality rules apply here too.
Yes. Strict confidentiality. Written genetic information must be kept in separate, confidential medical files, just like ADA medical info, with very limited disclosure exceptions to the employee for certain research, court orders, government investigations, FMLA, or specific public health issues.
And like the others, no retaliation, and employers need to post notices about G.
Correct, on both counts.
Okay, wow. We've covered the main types of discrimination prohibited by these regulations. Now let's pivot to what employers need to do proactively. Developing clear policies seems foundational.
It really is step one.
Yep.
You need clear written policies stating discrimination and harassment based on all protected characteristics are prohibited. And critically, this needs visible backing from the top senior leadership. Commitment is key.
What makes a policy effective, though? Not just words on paper.
Right. It needs clear definitions, easy to understand language, examples relevant to that specific workplace. Crucially, multiple avenues for reporting people need safe ways to come forward, not just their direct boss.
Multiple avenues. Good point.
Yeah. And clear procedures for prompt, thorough, impartial investigations. Assurance of protection against retaliation is vital. A commitment to take corrective action if needed, and maintaining confidentiality as much as possible.
And these policies need to be communicated effectively.
Regularly.
Yes.
Onboarding, handbooks, training sessions. People need to know the policy exists and what it says. Federal agencies actually have specific requirements here, like a separate anti-harassment program and using neutral investigators.
Okay, so strong policies, well communicated. Then comes the complaint process itself. Needs to be accessible and trusted.
Absolutely essential. If people don't trust the process, they won't use it. Multiple reporting channels, maybe an ombudsman, a hotline, options. And when a complaint comes in, the employer has a duty to act.
Meaning?
Prompt, thorough, impartial investigation. Gather facts, interview relevant people, assess credibility fairly. Based on the findings, take appropriate corrective action.
And appropriate means?
It should be proportionate to the offense, aimed at stopping the conduct and preventing it from recurring. And maintaining confidentiality throughout is important for everyone involved. Again, federal agencies have specific timelines and tracking duties here.
Which brings us to training. Policies and procedures are one thing, but people need to understand them.
Exactly. Training is crucial. Regular interactive training, not just a check-the-box video once a year. It needs to cover the policies, the procedures, what conduct is unacceptable, with relevant examples.
Interactive is key, you think?
I do. Makes it stick. And importantly, specific training for supervisors and managers. They're often the first line of defense. They need to know how to prevent, identify, and respond correctly, understand risk factors, and absolutely hammer home the no retaliation rule.
So training for everyone, but specialized training for managers makes sense. Fostering a respectful culture overall.
Yes. And maybe even bystander intervention training, empowering people to speak up safely. Federal agencies are mandated to provide periodic funded training covering all these bases.
Okay, let's dive a bit deeper now, specifically into harassment prevention. Can you recap the basic definition again?
Sure. Workplace harassment is unwelcome conduct based on a protected characteristic, race, sex, religion, etc., that is severe or pervasive enough to create a work environment that a reasonable person would find hostile, intimidating, or abusive.
Severe or pervasive. That standard is important, isn't it?
Very. It doesn't have to be both, but it usually needs to be more than just isolated incidents or petty slights, unless the incident is extremely serious. It has to be objectively hostile, and the victim must subjectively perceive it as abusive.
Okay. And liability, how the employer is responsible, that depends heavily on who the harasser is.
Critically so. If a supervisor's harassment results in a tangible employment action like firing, demotion, changing benefits, the employer is automatically liable. No defense.
Automatic liability, wow.
But if a supervisor creates a hostile environment without a tangible action, the employer might have a defense. It's called the Farragher-Ellerth defense.
And what does that involve?
The employer has to prove two things. One, that they exercised reasonable care to prevent and promptly correct any harassing behavior, like having good policies and complaint procedures. And two, that the employee unreasonably failed to take advantage of those preventive or corrective opportunities.
So the employee didn't report it when they reasonably could have?
Essentially, yes. Now, for harassment by coworkers or non-employees, the standard is different. The employer is liable if they knew or should have known about the harassment and failed to take prompt and appropriate corrective action. It's more of a negligence standard.
Okay, so supervisor harassment is treated more strictly, especially if it leads to tangible harm. And just to reiterate, harassment is prohibited based on
Race, color, religion, sex, including sexual orientation, gender identity, national origin, age 40 plus, disability, and genetic information. And retaliatory harassment is also illegal.
Can you give some concrete examples for different categories?
Sure. For race, maybe racial slurs or offensive jokes. For religion, mocking beliefs or imposing practices. Sex, obviously unwelcome advances, comments about bodies, quid pro quo, national origin, ethnic slurs, mocking accents. Age, derogatory comments about being too old, forcing retirement. Disability, mimicking someone's impairment, intrusive questions. Genetic info, comments about disease risk based on family history.
And this can happen anywhere: emails, texts, meetings, online platforms.
Absolutely. The communication method doesn't matter, it's the conduct.
So what are the top best practices for prevention, pulling it all together from EEOC guidance?
Leadership commitment, absolutely number one. Consistent accountability, everyone is held in the same standard. Clear, comprehensive, accessible policies, trusted, effective, complete procedures with prompt, impartial investigations, and regular, interactive, tailored training.
Plus being proactive.
Yes, monitoring the workplace for risk factors and addressing them. And when harassment happens, taking prompt, adequate corrective action designed to stop it and prevent recurrence. It's systemic, the response needs to be broader.
Okay, finally, let's briefly touch on enforcement. The EEOC is the main player here.
Yes, the EEOC enforces these federal anti-discrimination laws for most private employers, state and local governments, employment agencies, and unions. They investigate charges filed by individuals.
And there's a time limit to file.
Generally 180 days from the discrimination, but it can be extended to 300 days if a state or local anti-discrimination agency also covers it. Federal employees have a much shorter time frame and a different process. The EEOC website has all the details.
And they also pursue systemic cases.
They do. They focus on practices that have a broad impact, outlined in their strategic enforcement plan. Priorities often include hiring barriers, protecting vulnerable workers, emerging issues like AI bias, and ensuring remedies are effective.
Are other agencies involved?
Yes. The Department of Justice, DOJ, handles discrimination cases involving recipients of federal funds and state and local governments. The Office of Federal Contract Compliance Programs, OFCCP, ensures federal contractors comply with non-discrimination obligations. And the No Fear Act promotes federal agency accountability.
So wrapping this all up, the takeaway seems clear. The eCFR, especially Title 29, Chapter 14, provides that crucial legal framework. Understanding it is essential.
It really is. But beyond the legal text, it boils down to those core actions. Clear policies, reliable complaint systems, effective training, and genuine leadership commitment. That's how you move towards prevention.
And it's not just about ticking legal boxes, is it? It's fundamental to creating a workplace where people feel respected, safe, and able to do their best work.
Exactly. Prevention isn't just a compliance issue. It's a business imperative and, frankly, a moral one. It fosters respect, inclusivity, and ultimately a more productive environment for everyone.
So as our listeners reflect on this, maybe a final thought. Thinking about your own workplace, or one you're familiar with, what's one practical step, maybe something small, maybe something bigger, that could be taken today to strengthen that commitment to a discrimination-free environment based on everything we've discussed from the eCFR? Moving beyond compliance to truly embedding respect.
Thank you, viewers, for watching. If you found this video helpful, don't forget to hit that like button and share it with your colleagues. And if you haven't already, make sure to subscribe to the channel by clicking that subscribe button below so you never miss out on valuable insights. I'm Brian Edmonds, signing off. See you in the next one.